I'm attorney Zach Townsend, owner of Pro Legal Care. I have been representing clients in child custody cases and other family matters since 2011. I know that when you have a case that involves your kids, it can be very scary, but I'm not scared. I've been doing this for a long time, and I can help you. We used to have the word custody and visitation, and sometimes we still think of it that way. One parent has custody and the other parent has visitation, but that has changed. Instead of one parent having custody and the other parent having visitation, now both parties have parenting time divided between them. The law changed in Illinois in 2016 for guys who felt marginalized as parents, who felt like they were relegated to some kind of second-class parent that only was allowed to visit with their children. Both parents should be allowed to parent their children. Now, instead of custody judgments, we have a judgment of the allocation of parenting time. Another way to describe it is a judgment for the allocation of parental rights and responsibilities. That's a mouthful. Sometimes judges will still even tell you, I'm going to award you what we used to call custody. Now, parties don't have custody agreements, they have parenting plans, and the division is a lot more clear that way. When you want custody, do yourself a favor and use specific terms. Specify what you're looking for. What authority are you asking for when you say that you want custody? If you use those types of specifics, it's going to help you with communicating with your attorney. It's going to help you with communicating with the judge. There are many different misconceptions on what it means to have custody. Does that mean that you can move away? Does that mean that you get to make all the decisions? Does that mean you get to claim the child for income taxes? Does that mean you get to decide the child's parenting time with the other parent? Does that mean that you get to decide what information goes to the other parent? No. Those terms are specifically delineated, usually, in a parenting plan or a court order. There usually is not a general overarching authority like custody that gives you the right to do all those things. Those are individualized and those are detailed and specific. However, if you have to, you might say that you have residential placement because the child lives with you, or that you are the primary parent because you are the one that does most of the day-to-day care. One parental right that is fundamental is the acknowledgement of your parentage, the legal acknowledgement of you as the parent. This is especially important for fathers. That's called paternity. Paternity is a baseline parental right, and on top of that, you have lots of other parental rights and responsibilities that are built upon that foundation. The acknowledgement of your legal parentage sounds simple, and it is, but it's fundamental, and it affects the rest of the rights that follow. The right to be on the child's birth certificate, the right to be recognized on medical documents, school registration, and other important paperwork for the child that you are the parent. The right to parenting time. That includes regular parenting time, holiday parenting time, vacation time, and other special occasion parenting time. The right to access records. That's an important parental right. You should be able to have the right to access medical records, school records, to be able to log into the MyChart or the online healthcare medical records portal, or the parent portal, so you can see the child's grades, or discipline activity, or attendance. That's a parental right. The right to have updates and to be notified in the event of a medical emergency. The right to know where your child lives or where your child goes to school. The right of first refusal. That means that when the parent that's designated to have parenting time is unavailable, that you have the right to have parenting time instead. Decision-making authority is one of the most vague and abstract parental rights. It's intangible, and you just can't put your finger on it the way you can the other parental rights. Decision-making authority applies for significant decision-making only. That means that you don't get to make all of the day-to-day decisions if you have decision-making authority for your child. That's because the day-to-day or routine decision-making for the child happen and occur or decided by the parent that has parenting time at that time. This only applies to major decisions. What religion is the child going to be raised in? What faith will the child be raised to believe? What school will the child go to? Will the child have a medical doctor or a holistic doctor? These are the types of major decisions that come with decision-making authority. In other words, decision-making authority applies for significant decisions or major decisions that are made about the child, not all decisions. When you don't have a parenting plan or an order that sets forth each party's parental rights, that's unsafe and it's unsound. You don't really know what's going to happen. Even though certain Illinois laws provide that the parental rights default to the mother when there is no parenting plan, the lack of specificity and the lack of definition makes it wholly inadvisable. You need a parenting plan, and you need one well written, because without a parenting plan, you have no enforcement. The parenting plan is the roadmap to your parental rights. It's what memorializes your parental rights. It specifies the schedule, the decision-making authority, the right of first refusal, and the right to information. If you don't have a parenting time schedule or a parenting plan, you are going to have essentially an impossible time enforcing your parental rights. It's not just what the parents look at for their parental rights. It's what the child's school will look at. It's what the child's doctor will ask for. It's what the judge is going to turn to almost any time there's a dispute. The wording of your parenting plan could change the outcome of a dispute that you might have. Some parents that act in bad faith might even exploit vague wording in the parenting plan. We draft parenting plans in anticipation of problems that don't exist yet. We've seen thousands of parenting plans. We know what a bad parenting plan looks like. That's why we are very careful when we draft our parenting plans to make sure that you understand it and that it's clear and that it's comprehensive. When your parenting plan is unclear, that provision might be just completely unenforceable. You might have to go back to have the parenting plan rewritten. That means more litigation, more court costs, more drawn-out legal battles. You need a parenting plan that's going to prevent those types of problems before they occur. Parenting time is more of a clear parental right. If you are expected to have your child back on Sunday night at 6 p.m. comes and you don't have your child back, that's a violation. But what is a violation of joint decision-making? Joint decision-making is not a very clearly defined parental right. For that reason, enforcement of joint decision-making can be tremendously difficult. Judges can become exhausted from dealing with disputes that relate to joint decision-making. What happens when the parents can't decide which school a child will attend? Does the child just simply not go to school? Does the judge, who doesn't know anything about this child, decide where the child goes to school? This is a very challenging parental right. Decision-making authority is nebulous and sometimes requires more good faith than other parental rights. How do you get a parenting plan? And what happens if you can't agree on the terms of the parenting plan? There are essentially two ways that you can arrive on a parenting plan. You can mediate and you can have a judge adjudicate the parenting plan. If the parties are able to reach an agreement on their own, that's where the parties mediate their way to a parenting plan. If the parties cannot agree on the parenting plan, that's where the judge has to intervene and adjudicate the parenting plan and order it as a judgment over one or both parties' objections. Mediation is usually the most successful route to an agreed upon parenting plan. Mediation is where both parents sit down with a mediator who is like a third-party neutral arbiter who is trained to facilitate an agreement between two parents. Mediation allows for the parties to find common ground, and it can save a lot of stress, time, money, and a lot of lawyer fees. Even if you don't think that mediation will be successful, oftentimes it is. The nature and the process of mediation can really vary widely, but one of the standard models for mediation is that there are 3 sessions of mediation, and each mediation session is 1 hour each session. That allows the parties to make some progress and then to take a step back, maybe sleep on the different types of issues that were discussed, and then to come back and try to finalize the agreement. Mediation usually is at least a partial success, but if they agree upon at least some of them, that's a good start, and they could at least move forward on the parts that they do agree with each other on. Mediation ends with an agreement or partial agreement, or with the mediator kicking the case back to the judge and making the judge decide, and the judge to adjudicate the parental rights and enter an allocation or a judgment for the parenting plan in court. One of the most common next steps after mediation fails is that a guardian ad litem is appointed. A guardian ad litem is an attorney appointed to represent the interests of your child or your children, and it's the court-appointed expert, and the role of the guardian ad litem is to be the eyes and the ears of the court. The guardian ad litem has a 2-part role: to investigate and to recommend. First, the guardian ad litem investigates by interviewing the parties, perhaps visiting the home, or interviewing the child if the child's old enough. And then part 2 of the guardian ad litem's role is the recommendation. The guardian ad litem will, after an investigation occurs, provide a recommendation to the court. The recommendation is what the guardian ad litem thinks that the parenting plan should say. The guardian ad litem has the ability to provide specific recommendations or general recommendations. But either way, it's what the guardian ad litem believes, as the child's advocate, what would be in the best interest of the child. Some high conflict cases or cases that involve mental health issues may require the use of a custody evaluator. A custody evaluator is another expert that is appointed to provide insight with respect to the arrangements that the parties might be able to use as far as their future parenting plan and what might serve the best interest of the children or the child. The custody evaluator has a clinical perspective where the guardian ad litem has a legal perspective. Getting a custody evaluator involved in a family case is rare. It happens, but it's a bit unusual. Usually it's not best for the families to have the case rise to this level and to have such conflict that you need yet another expert to get involved, add to the stress, and add to the expense in this process that really should be focused on what can we do to serve the best interest of the children? What arrangements are going to be best for the family as far as a parenting plan is concerned? What happens when the parents can't reach an agreement? They've gone to mediation, but mediation has failed. They've had a guardian ad litem appointed on their case. The guardian ad litem has made a recommendation, but the parties don't agree on the recommendation. A custody evaluator has been appointed, has done a clinical review, but the parties are still unable to reach an agreement. What happens at that point is the judge intervenes. This is called a trial. This is the opportunity for the parties to present their case, to have witnesses called, testimony heard, exhibits submitted, other evidence provided to the judge for consideration. And then the judge, after weighing all the evidence, decides what arrangement is in the child's best interest and orders that as a judgment. It can take years to get to this point. The judge doesn't want to be responsible for a little child's future. The judge wants the parents of the child to be able to work it out. That's one of the reasons why the judge will delay or try every way possible until every avenue is exhausted at getting the parents to reach an agreement based on a settlement. Involving an attorney early on in your family case can help avoid the need for a trial, especially if you have a problem-solving attorney. I'm a problem-solving attorney. There are other types of attorneys that are problem-making attorneys. We want to be part of the solution. We don't want to be part of the problem. If you are headed towards a trial, especially if you are self-represented, you need help. Trial is hurtful for families. It is destructive to the little that's left of the co-parenting relationship. It provides a forum where things are said that can never be unsaid. Both parents are more likely to have a successful future when they get to decide what the parenting plan says. Both parents are more likely to follow the parenting plan if they have input on what the parenting plan says. There are a lot of myths about custody. It's a word that is inherently confusing. You need a parenting plan that delineates your rights and provides you a roadmap for your parental rights and what you're entitled to. The language of your parenting plan should be clear and drafted in a way that prevents problems in the future. I'm experienced in this type of work. This is the primary focus of my practice. Call me, text me, we can set up a consultation. I can provide you your options and give you a new path forward.